Hi, I'm Joe Fagan from Fagan, Fagan & Davis, a criminal defense firm in Northern Illinois. One of the questions that comes up a lot, people discuss often in their cases, is the concept of court supervision. It's one of the authorized dispositions that the law provides for misdemeanors and traffic matters. To understand what court supervision is, you have to understand what a conviction is. A conviction has three basic supports. It's like a tripod. The first is the judge or the jury has to make a finding of fact, or there can be a stipulation or agreement to the facts, or there can be a plea of guilty, which in its nature agrees to the facts. Second, there has to be a determination of the applicable law. That is, a description of what the law is and the implicit statement that those elements defining the law have been met. And third, to form a conviction, the third and most important leg for our purposes is the entry of a judgment on the findings. So you've got the finding of fact, the finding of law, and the term judgment on the findings. When a judge has said judgment on the findings, that case is over. It is a conviction. And all of the things that come with a conviction then follow. It can never be expunged. It can stop something else from being expunged. It can cause problems of all sorts. It's the one thing you always want to avoid when you're charged with a serious traffic matter, a DUI, or a crime. So what is court supervision? Well, the law provides that first offenders, and there are differing definitions of what is a first offender, but first offenders who have not had a bad history, in other words, their criminal record or their traffic record is clear or clear enough that a judge could go along with court supervision. And in that case, something very interesting happens. The court makes a finding of fact and a finding of law, but the judge then withholds the judgment pending the outcome of the supervision. Now, I've heard a judge explain this to one of my defendants while taking this was a negotiated plea, while taking this negotiated plea. It was just perfectly put for anybody to understand, so I'm going to repeat it. The judge said to the client, look, I've got enough here to convict you and have this mark on your record forever. Close the file, put it away, and I'm done with you. And you're done with me. But you've asked for court supervision, and here's what's going to happen. I still got enough to convict you. But instead of convicting you, I'm going to give you these conditions. These are several things that you must do and several things that you cannot do. I'm going to put that file away. I'm going to look at it from time to time. And at the end of the period of supervision, we're going to open it up for a final determination. If you have done the things that I require you to do and not done the things that you are not allowed to do, then I'm going to terminate the case, not only without a conviction, but with a discharge. And that is a huge, huge significant matter for a person who's got one case and one case only, or only a very, very minor criminal record, because it is an opportunity to keep that record clear. So if it's available, if your case fits the profile of some matter that can be dealt with in supervision, it puts a whole different light on the case. And it certainly affects the decision of whether or not you're going to go to trial and take the risk that after a trial a judge won't give you supervision. I'm Joe Fagan of Fagan, Fagan & Davis. If you're facing a criminal, traffic, or DUI matter, give us a call at the number below. Let's see if we can help.